All right. It's 12:31 according to my computer. So we're going to go ahead and we are going to start. Um,
that they can start preparing for it, because it's just a really different kind of conversation than they've probably ever had, especially regarding these issues. So I've spent a lot of time talking to them about the process and explore what their expectations are, what their concerns are, and let them know that a good agreement is one that's going to cover both of those things enough. They're going to cover their concerns and be a safety net for them moving forward. But also what I'm trying to do is refer them to other people to get their questions answered. And we'll talk about that in a little bit, but that's key before they show up for mediation. Can you go to the next slide? So then the mediation session itself is, I tried, what was written in the rules that it will be set no later than 3 weeks from when I get the referral. So the referral right at this point comes to my office, and then I set. So y'all having trouble hearing me? I don't know what to do.
Your volume is going in and out, and I don't know why, because you're not moving. So yeah.
I'm looking at the audio settings. They're all really high. Okay, does this change it at all? I just turned everything up higher on the settings. Okay, it's a little better. I'll just try to talk really, really loud. Is that better? Yeah, I think I'm closer to the microphone. I'm so used to using Zoom, which does not have this problem. Okay, so the goal is to set the mediation appointment 3 weeks from when I get the referral. And at this point, all the referrals come to my office. That may change down the road, but at this point, they come to me. And the key to being able to set the orientations as well as the mediation sessions is that I have contact information for the parties. There's no place for that on the form at this point. So I'm relying on the clerk and or the parent attorney whose email I will have. But what I'll be looking for right off the bat is phone numbers and emails of the parties themselves. Okay, I'll try to talk slow and loud and tap my head at the same time. I'm so sorry, it's not y'all. But yeah, thanks for telling me to slow down. All right. So in the session, we're not going to go longer than 3 hours. We can always set up a second session, no problem. In fact, that often in mediation works better, because to expect everybody to agree on everything in 3 hours in one session is a high bar. So the mediator is not opposed to setting a second session if the parties are. And not always do we use a caucus, but in my experience, when I mediated permanency mediations in Durham County, when I and another mediator were working under a Dave Thomas grant, we found that especially with cases, TPR cases, the best thing was to have at least one caucus to make sure people were on the same page, because of the power differential and just the emotion in the room, that we often were missing things or that people weren't saying things. So another rule is that there'll be at least one caucus for mediation.
Stephanie, can you explain what a caucus is compared to a mediation session?
Yes, we're meeting privately with that party, and we set up certain rules beforehand, like we're not going to keep secrets, so we don't want somebody to tell us something that they don't want the other party to know. That's rarely happened, but that can cause a problem ethically if we hear something that we really should be reporting to the other party. So that's, and we also let them know we're going to try to keep it within a certain time frame, at least letting the other party know, say 10 minutes has passed. We want to then go to the other party and talk with them for a little while and then come back. So typically we don't need to stay in caucus very long, but it's really crucial to get to certain concerns that people have that they might not be expressing or even are very aware of. Because our goal in mediation, I think you can go to the next slide. Our type of mediation that we do is called the facilitative model, which means that we are really focusing on the process, and our goal is that people exchange information productively. As long as they're exchanging information, we feel like we're doing our job. Of course, an agreement would be wonderful, but that's not our North Star. Our North Star is, are they exchanging information productively and respectfully? So the people who attend obviously are the parties. They can invite others if everyone agrees and the mediator feels that it's productive. I've told the mediators who I'm training that if anybody wants a child involved, they need to stop and tell them we're not sure and talk to me, and I have to talk to our lawyers, and we'll see. There might be a way to include them for part of it, depending on their age and the reason the parties want them there. But right now, I don't know if we're going to have a lot of requests for other people to attend. We'll see, but it's certainly an option. I feel like I'm missing something. Oh, yeah, well, so one of the main goals of the orientation is, again, to send people to their lawyers, their social workers, anybody they can, to get information and help before the session. The mediators are not going to be reviewing the file. We're not going to have anything other than the referral and some of the background that I get during an intake. And mostly what I want to know during the intake or the orientation is, what are their expectations? I want them to go and talk to their attorneys, social workers, whoever, to find out how realistic those are. I think it's by design that we know nothing. Some of the mediators have expressed concern because on the form J135, which sends some juvenile cases to custody mediation on visitation issues, it is clear what can and cannot be agreed on, like overnight, no overnights, supervisor, no supervisor. The judge fills that form out. It was intentional, I believe, not that I designed these things, but I believe the intention was that we would not have that information, and that the parties themselves would be, free to discuss. They're always free to discuss anything, but that also they could agree on anything, and then the judge would review it. But we want them to come in with realistic expectations for everyone's sake. And yeah, so instead of that, where again, the orientation and the referral back to people who can help them is key. All right, so you can go to the next slide, please. If they reach an agreement on the form that Anik had up, I think it's 215, there's space for the writer, for the mediator to fill in the terms of the agreement. And at least in the beginning, we'll probably have two mediators, one to type up any agreement right there during the session. So we'd like to be able to bring it up on the screen, because these mediations are going to be online. We'll be able to bring up the terms of the agreement on the screen for everyone to review. And also I should say that as I train more mediators, there will be a chance to do some in person if that's what people want, if both parties are requesting that. So once there's signatures, then we send this to the parties, just the parties, and we instruct them how to deal with the signatures, because there's a whole signature page and affidavits, et cetera, et cetera. Once it leaves us and we send it to them, we give them kind of a realistic date to get back to us if they want any changes. But other than that, the mediator's role is finished. Whereas in custody mediation, it's not finished. We shepherd the signed agreement to the judge. We track whether it's signed or not. We don't track that. That our job is done after we send it to the parties with their instructions. Once they both sign it, then the court has like 2 days to review it. But I got clarification that it's not until both parties have signed it. My concern was, where are they going to go to sign this? I mean, it seems like a lot, but I was assured that, well, the parent can go to their attorneys, the foster parents can get some help from DSS perhaps, and then who submits it? Well, it could be, again, those different attorneys could submit it. The parties themselves could take it to court. I'm trying to get clarification on what happens if they don't agree. Is the mediator reporting that information to anyone or not? Because we're not to keep statistics on this, except maybe aggregate data, but I don't know if we are then supposed to notify anyone that no agreement was reached. I'll find out soon, I hope. Okay, the next slide. Oh, these are just some slides I was going to show you of when I'm training mediators. So the mediators are custody mediators, so they have a lot of experience mediating family disputes and understand the family dynamics. And I'm now training them in these kinds of mediation. So in the beginning, they'll be watching me, and I have a lot of experience mediating permanency mediation in Durham and some in Wake County. A lot of those were, again, towards the TPR. And we definitely discussed post-adoption contact, though we couldn't write it up. People spent a long time talking about that specifically. And one of the things I learned is, there's no one size fits all for people who want to talk about that. I think some people feel that this program is really ideal for kinship adoption, but we were dealing with all kinds of cases. Again, just like Anik said, people who are on their way to be serving very long prison sentences, who still wanted to talk about contact. Could they write even 1 or 2 letters, things like that. So I really think eventually we will be getting referrals from a range of cases. So these are just some things that when I'm training the mediators, I want to remind them about the agreement that they're writing. And the next slide, please. And that it's gonna need to be very clear so that people are not back in court over and over again. In the agreement, I think even on that form, it explains that any modification cannot expand the terms of the agreement. That will be gone over again during the mediation, during the orientation, so that everybody's very clear on that. Yeah. The mediator's already paid. We are state employees. So there's some mediators, custody mediators, who have more time available. If I feel like if I train enough mediators, we have 47 statewide, then I mean, we don't have a clue how many referrals we're going to get. So we'll kind of see how this goes. But even if we, if eventually enough mediators are trained, it won't be a burden on any of them in any one district. And there's some mediators who have time designated for additional projects like this. Something else I'm forgetting. I think one of the questions that's going to come up, because I've already gotten it from a parent, is where can they go to get help with helping the child adjust from a plan that was an amount of time visiting their parent that was on the road towards reunification to now a very potentially different amount of time. So this question is coming up. Where can they go, to discuss that? And the foster parents have, post-adoption support. The parent doesn't necessarily have those resources, so I'm reaching out to some parent ed groups to see what they have. But I think that's going to be a key part of preparing people for mediation. Okay, next slide, please. My hope is to make some kind of orientation video like we have for custody mediation. The one we have for custody mediation is super impactful. And so I'd like to be able to create a video, or at minimum, a kind of slide presentation with narration that helps the 2 different parties prepare for mediation. And again, these different kinds of resources that I can give people during the orientation. Questions?
So I see that Mary she asked, do we have cooperation from the Department of Adult Corrections to allow incarcerated parents to be able to participate in these remote mediations?
I don't know.
I don't either, right? I think, Mary, that's going to be a bridge that we're going to have to cross. And not only that, but I think that there's going to be a difference between a Department of Adult Corrections, a general policy, and each individual facility. I know that there are certain facilities that are much more cooperative than others, but we're going to have to try it.
Yeah, I know that again, in Durham, when I was mediating, also in Fayetteville and Wake, when there was a party the party was brought to the mediation, escorted by a deputy and the whole 9 yards. I don't know who paid for that. I know that that does cost money, but that wasn't unusual.
Okay, so Susan's other question is, if the parties come to an agreement, does the case have to be mediated? Well, it has to be reduced to the form, right?
Right.
So I think it will be a very short mediation at that point.
Yeah, that would be great. Yeah, I don't know. That's a good question, but we're happy to type it up. And another thing that's I'm curious if post-adoption contact might come up in the context of other mediations, like a permanency mediation or some other kind of discussion. That happened a lot again in the permanency mediations I was conducting. And I asked our lawyers here about that, and they said that, well, then that piece of it would have to get referred specifically to this kind of mediation. I think what it could be, though, say I was mediating guardianship versus TPR, and they decided, the conversation came up to post-adoption contact and a voluntary relinquishment. Okay, they could just stop everything and send that piece to mediation, or everybody could just leave the room and we can mediate, because I think the key is that it would just be the parties and the mediator at that point.
Yeah, so one of the other questions that we've received from Whitney is, what about a juvenile over 12 attending mediation, since their consent is required for adoption, or is the GAL appearing on their behalf? And the answer is neither. The way that this has been done is that it is literally an agreement in a contract between the parent who is agreeing to sign a relinquishment and the foster parent or relative who is, you guys have lots of questions, which is great. This is exactly what we wanted, right? And I'm sorry, I need to scroll back to the question so we can get to it, okay? The GAL is not involved in this agreement. Again, this is an agreement that is made between the parent and the adoptive parent. It's those two are the ones that are involved. And I wanted to highlight in your handouts, I gave you 7B 909.3, and subsection C is the one that you need to be aware of, which is that the court may modify, right? This does become a court order. We're kind of jumping ahead, and I'm trying to figure out, do I want to rein it back in, or do I want to let it go with the questions that we're getting? And I think I'm falling in between the two, which is let's say that there is an agreement, right? And as Stephanie said, then what happens is that this eventually gets in front of a judge, who then has basically 2 days to go ahead and make it a court order. And you'll see that on Form AOC J215, what it does is that it makes it become a court order that is filed in the 7B action, but that directs the clerk of court to create a Chapter 50 filing. So I think that's the difference, right? And we're kind of used to it. We've seen some of these under the 7B 911. It's kind of that transfer of jurisdiction from the juvenile court to the custody court. And so that's what's going to happen here, is for enforcement purposes, it's going to go to the Chapter 50 action. So as she stated, the court may modify the terms. And when it says the court may modify the terms, that's going to be the Chapter 50 court. Either party can seek to enforce this contract, and the court may modify the terms in order, if the court finds by a preponderance of the evidence that there has been a material and substantial change in circumstances and that the modification is in the best interest of the child. And I think that fits in perfectly with what Chapter 50 usually does. That court is used to dealing with these kinds of issues. But you do need to be mindful of what Stephanie said, which is that they can limit, restrict, condition, decrease, or terminate the sharing of information and contact, but in no events can they expand or enlarge. So in other words, if the parties get along and they do that, that's great, but it's not going to be in an enforceable agreement. So,
And all modifications would first come to custody mediation.
yeah. So, then one of the other questions we had, and I'm trying to hit them all, since we have Stephanie here, who is the source on custody mediation, we can ask her these questions, right? What if DSS does not agree to mediate? Look, this is a no-lose situation for DSS. I get it that DSS may not necessarily want to, but here's what it does, right? If there is an agreement to mediate, first off, you can see this is a quick timeline, right? Within 3 weeks from the referral, it's going to be going to mediation, and they're going to do it pretty quickly. This avoids a TPR. Who's had a TPR here? How long does that take to hear, right? Everybody's complaining that we don't have a lot of court time. And also, if there is an agreement and there's and it's entered, there's no TPR, and there's also no appeal of the TPR, right? I don't see any way that this is a losing proposition for DSS, but I'm hoping that some of the DSS attorneys will speak up, because I probably haven't thought of the downside of it, right? I think the downside of it would be if there's not an identified, right, if they're relinquishing and there's no identified prospective adoption, but that's not the case here. There's a specific agreement in the form that this parent is relinquishing to this foster family or this relative. So I think these are people that hopefully that they have encouraged, and that's where they're headed for TPR. That is correct. The question was, do attorneys participate? Is that correct? The attorneys are not going to participate in the mediation. And part of the reason was, Maggie, that the foster parents are not going to have an attorney with them, right? So there is going to be a role for the parent attorney to review the agreement, but not for them to participate. And I think it's going to be mostly to explain it. Can we just jump ahead for a minute? And I see lots of other questions, including devil's advocate from Casey. But let me go to the advising clients when and what to say. Can you go on to the next? Because I think this fits into, right, what it is that we are looking at saying here. I think that this is going to be very much for us to remind our clients, our parent clients, to engage with the foster parent early on and to have a good relationship as much as possible, because it's going to encourage shared parenting. And I think shared parenting is going to be key in making an agreement that is satisfactory, or better chances of being satisfactory to both. One of the things that I just thought of is, we haven't really talked about what happens if there's no agreement. I think if there's no agreement, then you're right back to the TPR. So, or guardianship, or whatever it was that the court was going to adopt anyway. So I don't think this is a losing proposition in any way. Let me look at it. Stephanie, jump in at any point. I'm going to try to go through some of these questions. Devil's advocate: what is encouraging the foster family to participate and then obligate themselves to contact post-adoption? Most of them, they get TPRs on the wall. They can relinquish, or DSS can terminate it. I'm not sure the incentive to the fosters to participate and have extra rules to follow. They could just refuse and likely get an adoption free and clear later on. I think that a couple of benefits, right? The benefits to a foster family would be, now you're not in limbo. How long does it take to get to TPR? How long does it take to get to an adoption if you have to wait for the appeal of the TPR? What if there's a remand from the TPR? There's a lot of unknowns And so I think this is one way that it is an incentive for foster families. But again, I think one of the things that we have to talk about is when are we advising our clients, and whether that's, DSS, well, the foster parent is not your client, nor are they the GAL's client. One of the things that they have to think about is, do you want to sit through some uncertainty or not? And that's the same thing that we have to talk to our clients. And when would I say it? Would I say it on day one? Absolutely not, right? What's my client going to say about me? You're just trying to throw me under the bus. So these are conversations that we have to have with our clients that are open and honest. And I think the best way is that we're going to have these open communications. And that works best if we can have a cooperative environment between our client and the foster parent from day one. And this will hopefully lessen some of this pitting that I see. Sometimes, right, I see foster parents pitted against the parent because they want to adopt the child. And so they start sabotaging the relationship. And hopefully this will lessen some of that.
Anik, can I jump in and
Please.
say something?
Please.
I mean, one of the things I've already heard from a foster family, their reason for it is because for the child's mental health.
Mm.
So they understand what a big thing this is going to be for this child to make this adjustment. And they want her to have contact with the parent. But they want it in a way also that covers their concerns, right? So if they did this without an order, they would not have they would still have a way to enforce their role, but this makes it very clear to everybody what the rules are. And it is enforceable.
Yeah, I see. One of the question is, what if it's not enforceable? This is what changes, right? This is what this law does. This is an enforceable contract. This means that now, if, for example, and let me say this as well. Stephanie talked about it before, which is we have to manage expectations. If our client is walking into this mediation thinking that they're going to get every other weekend and 4 weeks in the summer with their kid, this is not going to work, right? This is an unrealistic expectation for someone who is getting ready to face a TPR. So, for the client, Laurel, who's sitting in prison facing 40 years, her remedy might be that she can, the agreement might be that she can write all the letters she wants and she'll get at least a monthly update or an annual update or something like that. So this is enforceable. It's enforceable in Chapter 50. And I realized that they don't have, either party has an attorney in a Chapter 50 proceeding, but they are used to enforcing custody agreements. The question from Alex, is this limited to parents who are contemplating relinquishing, or can parents who have already signed a conditional relinquishment seek a post-adoption contact agreement? I think this is really going to depend on the DSSs. Stephanie, I think you mentioned that there is a current referral, right? We have our first case that has been referred to the program. And I happen to know that there's actually a case in an appeal, a current appeal. So this is how I think potentially attractive this is, right? There is an appeal of a TPR where there is potentially an error in it. And so I believe that the parties are talking about whether to set aside the TPR to allow this process to go forward. So I think it's open to wherever you can get it done, but it's probably easiest to do it if there's not already been a relinquishment.
I see the question about attorneys' participation, and if everybody agreed, I suppose, but that's, again, it's not really the way it was designed as far as I can tell, and everything that I've asked about it. The times that all the professionals are at the table is regular permanency mediation, when people are discussing, for example, guardianship versus TPR, or somewhere earlier in the process, a mediator could be there to have everybody talk about all these issues and maybe even start to frame it and funnel it towards post-adoption contact mediation, where just the parties would be present. I think also, for example, if everybody agreed, if the parties agreed on what the contract was going to look like, and then they all agreed they wanted the 12-year-old there to present it to the child at another session, that's something that could be discussed in mediation about how to do that, if and how to do that.
Yeah, so a couple of questions I'm seeing both, again, about the attorneys. So the reason that the attorneys were not included in this is because the only party that would have an attorney is the parent, right? And so one of the issues was, would it be fair to have only the parent attorney present in the room when it's a negotiation between the adoptive parent and the parent? And so, because let's be honest, at the end of the day, DSS and GAL are out of it, right? They are not part of this agreement. They are not part of what enforcing this agreement is. One of the things that I know, some counties have moved away from taking specific relinquishments. I think this will encourage them to take specific relinquishments. They don't want it. They're just as tied up as you guys are. The reason they didn't want specific relinquishments was that, let's say Laurel in our situation, right? Laurel comes and she says, well, I want my mom to be the specific, I'm going to do a specific relinquishment to her. And then grandma didn't follow through and there was no adoption. And now they have to try to chase back this parent to finalize a TPR. So I think that that's going to change that. By the way, I see Jason's comment. Again, there is it's not envisioned for any of the attorneys to be. This is an agreement between consenting adults, the parent and the adoptive parent, right? So, and again, I think don't forget that it's more likely that an adoption will occur if there's an agreement here, because then everybody knows what to expect. If you remember, I used to, back in the day, I used to remember some of my clients were told by the adoptive family, I'll let you see your kid. I'll give you a car so you can come and see your kid. And then of course, after a year or two, that would disappear. That's not going to happen now, right? There's an actual written enforceable order contract between them that they're going to be using. So I don't know what where the case is, and I'd rather not know, and I'd rather not publish it. I'd rather not announce it. Sorry.
No, one of the things that we do as mediators is really help troubleshoot how realistic an agreement is, how it's going to work, all the nitty gritty.
I think, yeah. And I think one of the things is that, some clients are satisfied with some things and others are satisfied with others, right? And so we have to have a discussion about that. And I think, unfortunately, we are sometimes the bearer of bad news. And it seems like I could see my client saying, you just don't believe in me and you don't believe you can win the TPR and you're throwing me under the bus and you're pushing me to do this. And by the way, it should never be a push, right? Because they have to be willing to participate in this process. Or you're going to get hey, I heard Johnny got a better deal. How come I can't have visits on Father's Day, right? And a lot of this is going to come down to, again, the relationships that your client and the adoptive parent are able and willing to make. And it may look very different under lots of circumstances. It may have to do with whether they're a relative or not. It may have to do with whether your client has criminal charges or not. But most of us know, and I think most of us have been in situations where we know that the writing's on the wall and that the TPR, it's going to be, it's going to happen, right? Unless something happens, some miracle happens, your client's going to have their parental rights terminated. And if their parental rights are terminated, they have zero say in anything. This at least gives them an option of coming to an agreement or not. Now, if they walk into a room, and I'm sure that Stephanie has probably seen this, and I think we have to give huge credit to the mediators who know how to work this, right? If somebody walks into a room and absolutely is locked in on a position, it's just not going to work. And I think that that's where the beauty of mediation comes in, which we attorneys are terrible about, right? Which is we're used to fighting for whatever our hardest line is. And so talking about like, what is it that you really want to know? You really just want to know how your kid is doing? Well, we can arrange that, right? Maybe it's just a letter. Again, maybe it's a phone call. Maybe it's more. And so advising a client and how to say it, I think is going to become more important. I see there's a question by Elisa. An adoption has already occurred. This wasn't an option. Yeah, they've been actively involved. It's not an option. It's not an option because the adoption has already occurred. I'm not even sure that it's an option for cases in which there's already been a relinquishment done, but the adoption hasn't occurred yet. I think, you know, it's going to be up to DSS at that point whether they want to do it or not. I don't see that is. Alex asked, after an agreement, can adoptive parents seek amendment or protective order if the bio parents start becoming a nuisance? Yes, and that's exactly when I would envision that this becomes an issue.
They could have it terminated.
They can have it terminated, absolutely, right? So that's that section that I read to you that is actually in 7B 909.3 letter C. So
the other thing I just want to say is there's also indirect contact, there's direct and indirect contact. And what I anticipate in a lot of mediations, like custody mediations where someone has a substance abuse problem, is tiered levels. If this and this happens, then they move to this. I could see that being part of the conversation. It's complicated, but it's possible. So something else to talk to your clients about is how to build from step one to a potential step two.
Yeah. So Maggie had another question. What about a TPR? Judge ordered TPR in October, but they get along. You know, could this work? Could there be a referral to mediation? I think the question is, it depends, right? As everything else in our world. And here's what it depends on. First off, is there an order? Because as we know, parental rights aren't terminated until the order is in writing, signed, and filed, right? So maybe it would be an opportunity to reopen the evidence. And to ask otherwise whether or not this could be a referral. And so I think you're going to have to approach your DSSs and see whether this is something that that everybody is open to or not. Willis wants to know, how does this process begin? Do we as attorneys advise our clients of this option? And yes, I think you do. I'm happy. I would like to hear back from you guys of when you think this conversation, when this conversation begins. I think this conversation begins when you start seeing the writing on the wall that we're headed to TPR. You know, I think that's a wake up moment when we start having to have an honest conversation with our client about like, look, here are the options that you have, just like you would if you, and I, by the way, never did criminal law, but if you were representing someone in a criminal proceeding that was getting ready to go to trial, you'd be talking to them about, here's the deal that they're offering you. Here's, you know, we can go to trial, we can have a bench trial, we can have a jury trial. Here are all the options. At the end of the day, our clients make the best decisions for themselves when they are fully informed of their options. So at least from my perspective, and again, we're early days in this, right? We are 42 days since this has become law. We have one case that has been referred, and I'm hoping that we have many more. But I think how we start is the conversation early on about getting along with foster families, because we want to try to finesse, and it helps in reunification also, right? The more shared parenting we have, then the more likely we are to be successful or have our clients be successful at reunification. And then if things fall apart, I know I had clients of mine when I represented them at the trial level that grew very comfortable with the foster family. And that's because they trusted that foster family to have their child's best interest at heart. And so that's the kind of relationship that we're holding to build, because either they can help them when the children go back home, or if worst case scenario, we're at TPR, then maybe we can have some contact afterwards. And don't forget that we do have a new provision also about reinstatement of parental rights, right? So let's say that while there is a specific relinquishment to an individual, and they're going to do the adoption, if for one reason or another the adoption falls through, or we end up in this kind of like nebulous situation, and well, now the parent themselves can also file a motion to have their parental rights reinstated. Now there are lots of reasons and scenarios that we have to cover, like it's got to be 3 years, a certain age, etc. But I think that this is a great option. I understand the concerns, and I would love to hear more concerns from you guys, right? And I think you've been voicing them, which is, is DSS going to accept a specific relinquishment or not? Am I, selling out my client if I tell them about this? Liana asks, are any idea how this is being rolled out to local DSS offices? I wonder if the range of options are being clearly explained to foster parents about the process. Not every agreement will involve in-person contact necessary, would be sending pics via email.
I'm doing that a lot in orientation as well, which is why it's so key to have an orientation before the mediation.
Yeah, I think, that's a great question, Liana. And I think that that's kind of what we're going to see, right? Because look, DSSs, they can't do this, right? They are not the attorney for the foster parent. So they cannot give legal advice to that, right? And they cannot, same thing with the GAL attorney advocate, right? Their client is not the foster parent. So I don't know that those attorneys can give legal advice on this. I think it's a more interesting question as to what about the social workers and the volunteers? Are they giving any opinions about whether this is good or not good? Mary, I understand that there's not a DSS training being given on this yet. My understanding is that there is something being put together, but again, there's a whole new section, by the way, in the manual that is addressing this. So there is some guidance on this. They just probably haven't seen it in their manual yet, right? But it is, I've seen the draft, so I know it's around, and they were trying to get it published before October 1st. And yes, Willis, this is a way to avoid a nasty TPR where everybody's feelings are hurt. But again, at the end of the day, both parties can walk away if the mediation doesn't work, right? And then we're right back to TPR. We've lost nothing, but we've gained the potential for something here. And I think what Stephanie said, right, which is if we're all keeping, the pluses out of this equation, then I think that would be helpful. Go ahead, Stephanie, you had something? Yeah.
Yeah, I mean, one of the things the foster parents said to me, because someone asked about the incentive for them, was that they have a relationship now with this parent, over the last year and a half. And so they feel like they want to maintain that. They want the child to maintain it. And I feel like there's more and more information out there, which I hope to be able to bring into orientation about the effects for the child, and what it means to grow up as an adopted kid, and when the other family has just kind of disappeared and no one talks about it. So I think people like this foster family are very aware of that, and they want to avoid that. They also want to avoid being stretched thin. So that's their thing. Like, what if the father now wants separate? Blah, blah, blah. So they have those concerns.
Right. And so again, Marius, to your question about shared parenting, yes, it really should be going on. And I think it's on us as parent attorneys, as well as DSS attorneys and GAL attorney advocates, to be pushed for shared parenting, because that's what the manual prefers, right? So I think that is ideal. But I will say, when I visited your area of the states, I thought I saw a lot of shared parenting going on. So I think that you guys already have it. It's just maybe not in your orders. And Willis, I do think that when the judge orders ceasing reunification, I think that this is the time that you start having this conversation. What about other questions? And again, we're in early days. We're going to revisit this issue as things play out and see, what happens. And I think I'm hopeful that a lot of the mediations end up being fabulous and great, and everybody walks away happy. But there may be some when mediation simply does not work. And I don't know that that's any different from any other type of custody mediation, right?
Right, and what we're hoping is that the conversation, whether it results in an agreement or not, results in a better understanding between them.
Yeah.
Especially in a kinship relation where they are going to be in and out of each other's lives. So that's why our focus always stays on helping them have a productive conversation.
Yeah. So we're at the end of our hour. I can't believe that it's flown by. We knew that you guys would have lots of questions. So here's what I want to challenge you to do, which is post it on the Parent Council listserv, DSS, GAL attorney advocates. Feel free to reach out to me directly. If things are working or not working, we want to know. Do we need to adjust anything? One of the things that Stephanie mentioned, for example, is that in the forms, there is not a place to put the contact information for either our clients or the adoptive family. And so that's going to be on us to collect that information and make sure that we pass it along quickly. So, yeah. Let me see. One last question here. If the parties do not come to an agreement, does it get referred to Chapter 50 court for review, or does a party need to file a motion? What do you mean if they don't come to an agreement, it's going to TPR, right? So it's not going to get referred to Chapter 50 for a review.
For the modification?
Unless you mean for a modification. If it's for a modification, then again, potentially they're going right back to mediation.
Right, and if they don't reach an agreement there, then I guess it goes to.
Yeah. Yeah. So hopefully we've answered all your questions. You guys were great. Thank you so much. And I'm sorry that we interrupted your lunch hour, but I'm really looking forward to hearing back from you guys. And anyway, thank you so much for all your time. Bye.